Hello, and welcome to the CAS Course in Professionalism mock trial. My name is Ken Williams, and I'm the chair of the CAS Professionalism Education Committee, which is responsible for this course. The mock trial as part of the course is an example of what might happen in a more extreme case if you do not follow the standards available to us as actuaries. As you view the trial, your responsibility will be a member of the jury determining if the defendant violated law. But I would also like you to think about what you've learned today and in the pre-working learnings, and consider that if the defendant has been following these standards. After the video is over, we'll have a few short questions for you to answer about your thoughts on this situation. I will now turn it over to our actuaries turned actors to perform for you the case of ABC versus CAA Actuarial Consulting. Bailiff?
All rise for Judge Judy.
Please be seated. Court is in session.
This honorable court, the District Court of Mayberry, is now in session. All persons having business before this honorable court, draw nigh and be heard.
Good afternoon. I note for the record that this court is convened virtually due to the unprecedented circumstances in which we find ourselves. All parties to this case have agreed to the virtual venue in order to achieve a speedy trial. Members of the jury, I thank you for being here. I am Judge Judy. This case arises out of circumstances that led to the insolvency of ABC, the plaintiff. It is a malpractice suit to recover damages that the plaintiff claims the conduct of the defendant caused. The plaintiff alleges that the defendant, CAA Actuarial Consulting, committed malpractice through the actions of one of its actuaries. Actuarial firms may be liable for the negligence of an actuary under their employ if the actuary violated the legal standards of negligence applicable to actuaries. In 2015, ABC retained CAA Actuarial Consulting, Inc. to perform actuarial services on its behalf. In performance of that contract, Mr. Dwayleen Shree-Root, an actuary and partner of CAA, issued actuarial reports that forecasted the ultimate claim cost for years 2016 through 2019. Ms. Schroot also performed analyses of ABC's unpaid claim costs as of December 31st for years 2016 through 2018. In September 2019, the Attorney General, acting on behalf of the Mayberry Department of Insurance, issued a report stating that the plaintiff, ABC, was insolvent, should be liquidated, and that any attempt to rehabilitate the company would be futile. The plaintiff claims that the insolvency was caused by the defendant's negligent performance of actuarial services, failing to follow generally accepted actuarial principles, as well as failing to exercise reasonable care when providing its forecasts and analyses. This case involves the provision of actuarial services. As such, the standard set by law in this case is as follows. An actuary undertaking the provision of actuarial services for a client has a duty to possess and exercise that degree of skill and learning ordinarily possessed and exercised by other actuaries of the same or similar specialty practicing in the community in which such care is provided. It is further the duty of actuaries to use reasonable care and diligence in the exercise of their skill and the application of their learning. Since the actuarial profession is self-regulating, its code of professional conduct requires a higher standard of care in performing actuarial services. As such, actuaries have not only a duty to their principals, but are responsible to the public and to uphold the reputation of the profession. Counsel for the plaintiff is Mr. Vinnie Gambini. Ms. Dwayleen Schrute is here today on behalf of the defendant as a witness. Counsel for the defendant is Mr. Saul Goodman. As the jury in this case, you are to judge the facts of this case based on the evidence presented to you and based only on the evidence. This evidence will consist of the testimony of witnesses, the exhibits marked into evidence, and any material that we read to you. During the course of today's trial, you will hear from attorneys on numerous occasions. Always bear in mind that the attorneys are not witnesses, and what they say is not evidence in this case, whether they are arguing, objecting, or answering questions. The attorneys are here as advocates and spokespersons for their client's position. Before I begin, I have massacred Ms. Schrute's name on multiple occasions. Ms. Schrute, could you tell us your first name again?
Well, my full name is Dwydeen, Mr. Dwydeen, but I go by Ms. Dwyla. Thank you.
Thank you very much. Let me now outline for you today's events. Today, we will hear evidence presented by the defendant through the testimony of Ms. Schrute. Ms. Schrute will undergo direct examination, which means that Mr. Goodman will ask Ms. Schrute questions. Then Mr. Gambini will be given an opportunity to question Ms. Schrute, which is referenced as cross-examination. Mr. Goodman will then be given an opportunity to redirect questions to Ms. Schrute. Counsel Goodman, are you ready to proceed?
I am indeed, Your Honor.
Bailiff, please swear in the witness.
Ms. Schrute, please raise your right hand. Do you affirm that the testimony that you will give in the hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Counsel, please begin.
Thank you, Your Honor. Ms. Schrute, please state your full name for the court.
Dwyla K. Schrute III, FCAS.
And who is your employer?
I'm a partner with CAA Actuarial Consulting Incorporated, and I've been with them for the last 25 years.
Very impressive. Ms. Schrute, what are your professional qualifications?
I'm an actuary. I've been a fellow of the Actuarial Society since, Casualty Actuarial Society since 1980, and I'm a member of the American Academy of Actuaries.
And what has your actuarial work experience been?
As I mentioned, I've been employed by CAA for 35 years, and during those years, I provided actuarial services to many clients.
Were the actuarial services you provided to your clients similar to those that you provided to ABC?
Yes.
Ms. Schrute, has the quality of the actuarial services you have provided to your clients ever been questioned?
Absolutely not.
Is your work reviewed by another actuary at CAA before it's released to a client?
Yes, at CAA, we require that all of our work is peer reviewed.
Ms. Schrute, please describe why you were retained by ABC and the services you performed for them.
In January of 2015, I responded to a request that was jointly issued by a group of 4 hospitals. The hospitals were forming an insurance reciprocal to provide medical malpractice insurance to the 4 hospitals. The request was for an actuary to provide the actuarial services needed. I was selected to be the actuary.
And what specifically were the actuarial services that would be needed?
The first task was to project the claim amounts ABC would ultimately pay for claims reported in 2016. This was to be done for each hospital. It was my understanding that this would be used to determine the first-year premium that would be charged by ABC to each of the hospitals. My second task was to similarly estimate the ultimate claim amounts for 2017, 2018, and 2019. My third task was to estimate unpaid claim costs at the end of each year.
The jury has been provided with a summary of the tasks, including the estimate you provided for each service. Jury, please take a moment to review. Ms. Schrute, does everything look accurate to you?
Yes.
Ms. Schrute, please briefly describe the work that you did for the first task, the forecast of the ultimate claim costs for the year 2016.
Sure. I began by requesting the most recently available loss runs and historical exposures for each of the 4 hospitals. The first thing I did once I received the information was to compile it into data development triangles organized by report year.
And after you've organized the data, what did you do?
For each of the 4 hospitals, I developed the reported claim amounts to an ultimate level by report year for each of the historical report years listed in the loss runs. Then I weighted the exposures to come up with the number of occupied bed equivalents, or OBEs, by year. Then I divided the ultimate losses by report year by the OBEs to come up with the loss cost by report year. I then trended the loss cost for each year to the 2016 cost conditions. Then, based on the trended loss costs that I calculated for each year, I selected a loss cost for the 2016 year. I then multiplied my selected loss cost by the forecasted OBEs for the 2016 year to come up with my forecast of the ultimate claim amounts for the 2016 year.
I see. Did you make any adjustments to your forecast of ultimate losses for the 2016 year?
Yes. In fact, I made 3 adjustments. First, since my initial forecast was on an unlimited basis and the coverage to be provided by ABC was limited to $3 million per claim, I divided my forecast of the unlimited claim amounts by an increased limit factor to adjust the claim amount to correspond to the $3 million per claim coverage provided by ABC. The second adjustment was to reflect the time value of money as requested to do so by the manager of ABC. Third, I was told that the risk managers for the hospitals were going to implement new service quality measures and risk management controls aimed at reducing future medical malpractice claim costs. Based on discussions with the risk managers, I lowered what my forecast would have been by 15%. The final estimate I calculated was $19.7 million, which was divided between the 4 hospitals. This represented the claim costs, including indemnity amounts and legal expenses, that ABC would ultimately pay for claims reported in 2016, discounted to reflect the time value of money. This was the number I presented to ABC in my actuarial report of 250 pages, including exhibits.
250 pages, very impressive. Did you have your calculation of the 19.7 million peer-reviewed?
Yes, my analysis was peer-reviewed by Michael Scott, a credentialed actuary.
And did Mr. Scott express any concerns with your analysis or findings?
No, he didn't.
After you presented your actuarial report to ABC, was there any discussion?
Yes, I was asked to present my findings to ABC's board, which I did on October 12th, 2015.
Good. Let's move on to your work to forecast ultimate claim costs for the 2017 year and the reserves estimate for 2016. The exhibit indicates you began this review in the 4th quarter of 2016. Is it reasonable to do a reserve review for a full year using data through September 30th?
Yes, actually, it's quite common for actuaries to do so.
Okay. Was the actuarial method that you followed to do so similar to the methodology you followed to forecast the 19.7 million as you described earlier?
Yes, the only real difference was that there was additional claim experience to consider, including 9 months of actual claim experience since the ABC was formed. However, this 9 months of actual claim experience was not useful, as it typically takes some time for a claims adjuster to obtain a good handle on what a medical malpractice claim will cost. So the reserves listed in the loss runs were basically placeholders until more information became known about each of the claims. Based on this, I selected $20.3 million as the estimate of 2017. This was 3% higher than the $19.7 million from 2016 and represented the trend I expected in claim costs over that year. There was nothing in the data I received over the last year to suggest that this was not reasonable.
So why did you select 3%?
It was a professional judgment I made.
Okay, professional judgment. Now, let's move to your projection of the ultimate claim costs for the 2018 year and the reserve needs as of the end of 2017. Was the actuarial methodology similar again to what you followed to your original forecast of the 19.7 million?
Yes. The only real difference was now that I had actual loss data through September 30, 2017 to consider in my analysis. But I didn't find this information very helpful as the claim information was still relatively immature. While some small nuisance claims were closed already, the claims that presented the greatest risk to ABC were still open at that time.
But didn't the case reserves that were carried on the open claims provide some helpful information to you?
Not really. The claims that were reported and were open at the time all carried relatively low case reserves. My ultimate claim estimate was $20.9 million, again representing a 3.3% increase over the prior year's estimate. My reserve estimate for unpaid claims from the prior 2 years was $37.0 million.
Okay, now let's move 1 year forward to your forecast of ultimate losses to 2019 and your estimate of reserves need as of the end of 2018. Did you use a similar methodology again to what was used in prior analyses?
Yes, except now that I had actual loss data through September 30th, 2018 to consider my analysis, it was this data that was surprising to me.
In what way?
3 different claims were settled for $19 million, of which a total of $9 million was the responsibility of ABC. There were also significant reserve increases in claims, including 39 claims which were now reserved for $36 million in total. Based on this, my reserve estimate for the prior 3 years evaluated at year-end 2018 was now $59.4 million.
So was this an increase over what you had thought it would be based on your year-end 2017 reserve estimate and the 2018 ultimate claim amount forecast?
Considering the claim amounts that were paid, yes, by about $9 million.
The exhibit indicates your ultimate claim amount for 2019 was $24 million. How did you arrive at that?
Based on ABC's claim experience, which was adverse compared to what had been expected, I raised my forecast for the 2019 year beyond the 3% trend I had selected the prior 2 years.
I see. And when did you present your findings to ABC?
I presented my reserve and forecast estimates to ABC's board on January 10th, 2019.
What was the board's reaction?
They seemed quite surprised and disturbed that my December 31, 2018 reserve estimate and 2019 forecast were as high as they were, and they asked how the numbers could have increased so much in 1 year.
And what was your response?
I explained to them that when I did my analysis at the end of 2017, there was absolutely no indication that their claim costs would be this high. It was only when I received the September 2018 loss run that this became evident. I said that the claims had nominal case reserves as of September 2017. Those were either now closed with very large payments made or reserved for very large amounts, including some for more than $2 million. I also said that there is nothing in the history of the hospitals that suggested their claim experience would be this bad or that they would experience adverse claim development to this degree.
Okay. Ms. Schrute, isn't medical malpractice characterized by a high degree of claim volatility?
Yes, it's not unusual for a healthcare entity to encounter some years of very good experience and some years of very bad experience. Unfortunately, in this case, ABC happened to experience bad experience in its first couple of years of operation.
So, Ms. Schrute, is it your position that you followed accepted actuarial procedures in arriving at your forecasts and reserve estimates, and that the financial results of ABC was simply due to unfortunate luck?
Yes, and in my opinion, some poor management on the part of ABC.
What do you mean by that?
Among other things, I believe ABC should have been more strongly capitalized. They should have included a larger risk margin in the premium that it charged. It should have asked me to perform interim reviews to raise my billable hours.
Your Honor, this concludes Ms. Schrute's direct testimony.
Mr. Gambini, do you wish to cross-examine Ms. Schrute?
Oh, most definitely, Judge.
Counsel, you may now begin your cross-examination of Ms. Schrute.
Good afternoon, Ms. Schrute. You know, I don't impress easily, but I gotta be honest, I'm quite impressed with your credentials.
Why, thank you.
You're welcome. But tell me, what is an attestation year?
I'll try. Members of the Casualty Actuarial Society must certify compliance with the Society's continuing education policy at the end of each calendar year. Compliance with the continuing education policy allows the member to provide actuarial services in the year immediately following the certification.
So, for example, attestation year 2019 means that the actuary certified compliance with the continuing education policy at the end of 2018. allowing her to provide actuarial services in 2019. Do I have that correct?
Yes.
Well, I checked your profile at the end of 2016, and it showed an attestation year of 2016 and not 2017. Why is that?
Really? Well, I'm not sure. I wasn't aware of that.
Well, doesn't this mean that you were not permitted to provide actuarial services in 2017?
I'm not sure. I'm fuzzy on what non-compliance with the continuing education policy means.
Fuzzy? I'll tell you what's fuzzy is my little cat. But let's move on. You said that Mr. Scott peer-reviewed your work. To your knowledge, has Mr. Scott ever performed a medical malpractice reserve or loss forecast study for a hospital?
I don't know.
You don't know. You selected him to be your peer reviewer, correct? Did you not at least give him advance notice to conduct an adequate peer review?
Of course I did. I texted him the night before. I text him all the time before the draft report was sent to the ABC.
You tested him. See from your references that the only hospital for which you provided actuarial services prior to being engaged by ABC was for a hospital called St. Mary's Hospital. How does St. Mary's compare in size to the 4 hospitals that are insured by ABC?
I believe it is smaller. In terms of bed counts, about half the size of the smallest of the 4 hospitals.
So at the time you prepared and submitted your proposal, you had no, I repeat, no personal experience in performing medical malpractice reserve studies for hospitals the size of the 4 insured by ABC. Is that correct?
Yes.
Tell me, where is St. Mary's Hospital located?
St. Mary's is in Oklachusetts.
And where are all the 4 members of the ABC located?
In New Troy.
So prior to your work with ABC, you never provided actuarial services regarding a hospital that operated in New Troy, correct?
No.
Ms. Schrute, would you agree that medical malpractice claim experience in New Troy is different than that claim experience in Oklachusetts, a much smaller state?
I don't know. It might be.
Well, would you agree that statutes and regulations dealing with medical malpractice claims may be different in New Troy than in Oklachusetts?
I suppose.
And to what extent do you reflect these differences in the analysis you performed?
I didn't reflect any difference explicitly. I let the data speak for itself.
What do you mean you let the data speak for itself?
I mean, to the extent that there are differences in the medical malpractice experience in New Troy versus Oklachusetts, for whatever reason, regulations or otherwise, it would be reflected in the claim data that I analyzed.
Does this mean that you did not consider any medical malpractice claim experience that may be available through published studies or insurance company rate filings other than the hospital's own experience?
That is correct.
I take it then that you found the hospital's claim data fully credible.
Yes, in my judgment, the hospital's data was sufficiently credible to serve as the basis for my analyses.
Your judgment, a judgment made by one who at the time of during the initial analysis had never, I repeat, never provided actuarial services to a hospital located in New Troy, nor the size of the ABC reciprocal hospitals. Wouldn't an actuary with more experience with medical malpractice have reached the same conclusions regarding the credibility of the hospital's claim experience?
How dare you, good sir. Your Honor, I object to the question and its tone.
Sustained. Mr. Schrute, Ms. Schrute, you seem a bit out of sorts. Would you like a break?
No, thank you. I'm fine.
Well, I'm so happy to hear that, Ms. Schrute. Let's continue. Let's now talk about the so-called triangles that you created from the loss runs you received. I gather that you took the loss run information you were provided and created a loss development triangle?
Actually, I created a loss development triangle for each of the 4 hospitals, as each hospital had a different claims adjuster prior to being insured by ABC with different reserving practices. handling its claims, and so the development patterns would be different.
Well, after 2015, when ABC was formed, did ABC continue to use the same four claims adjusters?
The hospitals continued to use their same claim adjusters for claims reported prior to 2016, but ABC hired a new claim adjuster to handle all claims for which ABC was responsible.
And presumably, this new claims adjuster followed different reserving practices than the other four.
I'm not sure. In the case of medical malpractice claims, it takes years before an actuary can determine what the unique development patterns are for a particular claim adjuster.
So what did you do?
I assumed that the losses would continue to develop as they had for each hospital.
Well, did you talk to ABC's claims adjuster about its reserving practices?
No.
So, Ms. Schrute, I gather then that you were not aware that ABC's claims adjuster's policy is to initially reserve all claims that are reported at $10,000 per claim and not adjust that reserve for a period of at least 1 year.
I was not aware of this policy.
Do each of the four claims adjusters have a similar policy?
I don't know.
But you assume they did. Is this not correct?
I suppose so.
You said that for your initial study, you reduced the claim amount forecast that you first arrived at by 15%. And that was to reflect future improvements in service quality and risk management. Is that correct?
Yes.
Tell the court why you determined a reduction of 15% was appropriate.
As I said earlier, it was based on discussions I had with each of the four risk managers. They told me of the quality improvement changes they plan to implement, which to me seemed quite impressive.
Well, I mean, have you ever worked in a hospital?
No.
Have you ever driven by a hospital?
No.
Do you know anyone who works at a hospital?
No.
So how in the world would you have any idea what constitutes good or bad service quality controls or risk management?
This is what the risk managers told me.
Ms. Schrute, do you know if those service improvements were ever implemented?
Actually, no.
You never asked in more than 3 years you provided services to ABC.
I don't believe I did.
And yet you continue to apply this adjustment each and every year. Why did you decide on a 15% reduction?
As I've said, it was based on discussions I had with the risk managers.
So you relied on the judgment of the risk managers.
Yes.
Did you state that you did this in your actuarial report? Take your time.
I don't see that I did.
Okay. Well, did you perform any analysis to test the reasonableness of this assumption?
I don't recall that I did.
Are you familiar with ASOP 41?
Not by number.
It's titled Actuarial Communications. Does this help your memory at all?
Of course, yes.
Your Honor, can we have Exhibit D, which is a copy of Actuary Standards of Practice 41, given to Ms. Schrute?
Bailiff, please give Ms. Schrute a copy of Exhibit D.
Thank you. Now, Ms. Schrute, please turn to page 5 and read to the court, please, paragraph B.
If a material assumption or method is selected by another party, the actuary has three choices. Number one, if the assumption or method does not conflict significantly with what, in the actuary's professional judgment, would be reasonable for the purpose of the assignment, the actuary has no disclosure obligation. And there's a second bullet that says, if the assumption or method significantly conflicts with what, in the actuary's professional judgment, would be reasonable for the purpose of the assignment, the actuary must disclose that fact and the additional information specified in section 4.3. And then there's a third bullet that says, if the actuary has been unable to judge the reasonableness of the assumption or method without performing a substantial amount of additional work, beyond the scope of the assignment, or if the actuary was not qualified to judge the reasonableness of the assumption, the actuary should disclose that as a fact as specified in section 4.3.
And please read paragraph C.
In all other situations, the actuary is responsible for assumptions and methods utilized in the preparation of a communication unless the actuary discloses otherwise within the communication by including disclosures identified in section 4.4.
Well, thank you, Ms. Shrew. You know, you stated that you relied on the risk managers for this assumption that claims costs would reduce by 15% due to the quality improvements implemented by the hospitals.
That's correct.
Did this assumption conflict significantly with what you thought is reasonable?
I really had no views on whether the 15% was reasonable or not.
So you didn't consider yourself qualified to judge the reasonableness of this assumption, correct?
Yes, that's correct.
So in your actuarial report, did you disclose that this assumption was made by the risk managers? The reason why they and not you made this assumption, and that you were not qualified to make this assumption?
I don't believe I made this disclosure in the report.
Are you aware that by not meeting the requirements of ASA 41, that you may have materially violated Precept 3 of the Actuarial Professions Code of Professional Conduct?
I guess, but it's just a disclosure issue.
Okay, Ms. Shrew. Well, let's take a closer look at the incurred development method that you applied in your initial study. Would you please turn to Exhibit E?
Bailiff, please give Ms. Schrute a copy of Exhibit E.
Please tell the court what Exhibit E is used for and what is it actually?
This is the incurred loss triangle I created for Alpha Regional that I used to estimate Alpha Regional's ultimate claim amounts by report year.
And Alpha Regional is the largest of the 4 member hospitals?
Yes.
I gather then that your estimates for Alpha Regional carry a considerable amount of weight in your overall estimate for ABC. Is this correct?
Yes.
Tell us, Ms. Schrute, why did you select a factor for the 48 to 60 time period of 1.000 when each of the averages you display is greater than 1.000? In fact, each is greater than 1.300.
I'm trying to recall.
Oh, please take your time, Ms. Schrute.
Oh, yes. Now I remember. You'll see that one of the historical factors was 2.7. This is clearly what actuaries call a data outlier, so I discounted that abnormally high factor.
What about your selection of 1.000 for the 60 to 72 month time period? Again, all the averages are well above 1.000.
Same reason. One of the historical factors was 2.25. This is another data outlier that I ignored.
Well, let me get this straight. A data outlier is an unusual data point that occurs rarely by chance. Yet here, in the case of this hospital, there are 2 high points that occurred, and yet you consider both to be data outliers?
Yes.
Was there another reason that's possible that these high points are not data outliers, but actually reflect the true development pattern for the hospital?
In my professional opinion, that is highly unlikely.
You mean the professional opinion of one who up to this point have performed a single medical malpractice reserve study for a much smaller hospital located in Oklachusetts? Ms. Schrute, if you had instead selected higher 48 to 60 and 60 to 72 development factors, would your 2016 projection been higher than 19.7 million, all else being equal?
Again, it's hard to say, but I suppose so, all else being equal.
Well, in selecting development factors for the other 3 hospitals, did you not also find high development factors that you consider to be outliers and hence you excluded them?
I don't recall.
Well, we can establish that later, Ms. Schrute. Were the reserve estimates that you provided to ABC discounted to reflect the time value of money?
Yes, as I was requested to do so by the manager of ABC with an investment rate of 6%.
Can you point us to a letter or email instructing you to use 6%?
I don't believe I can. As I recall, this was told to me over Snapchat.
Snapchat? Did you make any notes documenting this?
No,
When you were told to use 6%, did you find this to be a reasonable investment rate to use?
frankly, I didn't give it any consideration. I was told to use it, and so I did.
So you didn't ask about ABC's investment policies?
No,
So I take it you were not aware that ABC's investments were entirely in short-term securities, yielding an average return of a whopping 1%.
I was not.
Do you, as an actuary, have an obligation to question the reasonableness of investment rates you are asked to use?
I don't know.
Let me ask you this. Are you familiar with Actuarial Standard of Practice number 20?
Not by number.
Shocking. It's titled Discounting of Property Casualty Unpaid Claim Estimates. Does this help your memory?
Of course, yes.
Your Honor, can we provide Ms. Schrute with a copy of ASOP 20, which we have labeled Exhibit F?
Bailiff, please give Ms. Schrute a copy of Exhibit F.
Thank you. Ms. Schrute, would you please turn to page 5 and read paragraph C?
The actuary is responsible for the discount rates employed in preparing the actuarial findings unless the actuary appropriately discloses otherwise. The actuary should be guided by section 3.4.4 of ASOP number 41 when using discount rates requested by another party.
Thank you. So, Ms. Schrute, you stated you were instructed to use 6% investment rate, and so you did.
That's correct.
Okay. Do you know the amount of capital ABC carried when it was established in 2015?
Yes, $3 million.
Did you not state earlier that medical malpractice claims are characterized by a high level of volatility?
Yes,
And wasn't your projection of the 2016 ultimate claim amounts 19.7 million?
yes,
And wasn't your estimate of the year-end 2016 reserves 19.6 million?
yes.
So in your opinion, is 3 million enough capital to provide the type of claim costs and reserve volatility that is typically experienced in medical malpractice?
I'm not sure.
How are you not sure? Ms. Schrute, are you familiar with confidence level reserve estimates?
Of course.
Well, did you provide ABC with a 75% confidence level estimate of the reserve?
No.
What type of reserve estimate did you provide?
I provided an actuarial central estimate.
And what confidence level is that estimate?
For medical malpractice, about 55%.
Okay, so this means that for your year-end 2016 reserve estimate of 19.6 million, there was about a 45% chance that it would prove to be too low.
I suppose so.
So I'll take that as a yes. Does this mean that there was a 45% chance that the reserve estimate of 19.6 million would be so low that the shortfall would not be covered by the 3 million in capital?
Not really. The likelihood wouldn't be as high as 45%.
Well, what would the probability be?
Maybe about 33%?
So you think there was about a 1 in 3 chance that the level of capital carried by ABC in its first year of operation would prove to be insufficient to provide for its claim costs. Yet, Ms. Schrute, you said nothing about the adequacy of the capital level to ABC's board. Are you familiar with Precept 1 of the Code of Professional Conduct?
By the number, of course.
Well, would you please read the first paragraph from this copy of Precept 1?
An actuary shall act honestly with integrity and competence and in a manner to fulfill the profession's responsibility to the public and to uphold the reputation of the actuarial profession.
Well, Ms. Schrute, don't you think that the insolvency of this company and the negative impact on the hospital and, more importantly, its patients might result in negatively impacting the reputation of the actuarial profession?
Well, only if the jury decides against me and my firm.
Your Honor, this concludes my cross-examination, Ms. Schrute.
Counsel Goodman, would you like to redirect questions to your witness?
Oh, absolutely, yes, Your Honor.
Mr. Goodman, you may proceed.
Thank you, Your Honor. Ms. Schrute, my friend, dear Mr. Gambini here, might have left the jury with the wrong understanding of the services you provided. So let's correct those misconceptions, shall we? First, Counsel Gambini established that you did not file an attestation at the end of 2016 to provide actuarial services in 2017.
Yes.
Please explain why you did not do so.
I think the CAS website was down that day.
Did you satisfy the continuing education requirements as of the end of 2016?
Yes.
So the only thing you did not do was to log on to the CAS website, which is often down, by the way, and enter your attestation. An unfortunate oversight, but certainly this omission doesn't mean you were not qualified to provide actuarial services in 2017. Would you agree?
Yes, I believe exam results came out that day.
An important day. You stated to Counsel Gambini that you didn't consider external information. Why is that?
Medical malpractice claim experience varies greatly by hospital. In my opinion, it's much more appropriate to base reserve estimates and loss forecasts on the claim experience of that particular hospital.
Can we have a real-world example of that?
Yes. Considering another insurer's rate filing to estimate the reserve needs of ABC is like considering the batting average of the New York Mets to forecast the batting average of the New York Yankees.
Great example. Thank you, Ms. Schrute. You stated to Mr. Gambini that, in your opinion, the claim experience of each of the 4 hospitals is fully credible. Is that correct?
Yes, that's what I said, and that's what I believe.
And by credible, I assume you mean it's usable in a statistical sense.
Yes.
Ms. Schrute, are you aware of any actuarial papers that have been published that set forth well-defined rules for determining whether a body of claim experience is fully credible?
No. While many papers have been written that deal with credibility, and where there's some science behind how one determines if a body of data is fully credible, the determination of what constitutes fully credible data is largely a matter of actuarial judgment.
And in your professional judgment, the claim data for each of the hospitals was fully credible, correct?
Yes. Yes.
Ms. Schrute, in response to a question by Counsel Gambini, you also said that at the time you submitted your proposal to ABC, that you had not provided similar actuarial services to a hospital the size of the 4 member hospitals.
That's correct.
But is it also true that you had provided actuarial services similar to those requested by ABC to another hospital?
Yes.
And is it true that the type of actuarial services you proposed to provide to ABC is the same as you had provided to that hospital?
Yes.
That hospital for which you had provided actuarial services was small relative to these 4 hospitals, is that correct?
Yes.
Would you say that forecasting claim amounts and estimating reserves is easier or more difficult to do for a small hospital as compared to a larger hospital?
Forecasting claim amounts and estimating reserves is clearly more challenging to do for a smaller hospital.
And could you explain why this is the case?
Because the smaller hospital has less data to work with. Therefore, an actuary has to make many more assumptions, which increases the uncertainty surrounding the actuarial estimates.
So does the mere fact that each of the 4 member hospitals is larger than the hospital you had provided actuarial services before make you unqualified to provide services to ABC?
Not at all.
I'd like to take you back to another line of questioning by my friend, Mr. Gambini. You told Mr. Gambini that you had not discussed the claim reserve practices with ABC's claim adjuster. Is that correct?
Yes.
Now, why did you not do so?
Because I find the information provided by claim adjusters about their own reserving practices not to be reliable.
What do you mean?
Well, all claim adjusters tend to say the same thing, that their reserve estimates represent what the claim will cost, and that their case reserve estimates are always accurate. But the data actually shows this not to be the case, particularly for medical malpractice cases.
So knowing that ABC's new claim adjuster initially reserves each claim for $10,000 would not really have affected any of your estimates.
That's correct.
Ms. Root, you explained to my dear friend Counsel Gambini that you selected a loss development factor of 1.000 for each of the 48 to 60 and 60 to 70 time periods for Alpha Regional because you felt 2 of the data points were outliers. Is that correct?
Yes.
It was also established that each of the averages displayed on Exhibit E for those 2 time periods was higher than 1.00. Is that correct?
Yes.
Ms. Schroed, what is an all-year X high-low average?
It's an average of all of the historical factors except for the highest and lowest factors.
And is this average commonly considered by actuaries?
Yes.
Why do actuaries typically consider this average?
Because it removes the distortion created by unusually high or low factors. And because it removes both the highest and lowest factors, it's considered to be an unbiased average.
Now, did you show this average in Exhibit E?
No.
And why not?
This was an oversight on my part.
Now, had you shown this average, what average would appear for the 48 to 60 and 70 to 72 month time periods?
1.000.
And isn't that exactly the factor you selected for each of these time periods?
Certainly is.
Marvelous. Thank you for clarifying this, Ms. Schroed. Now, you stated that you reduced what would have been your 2016 forecasted claim amount by 15% to reflect quality control and risk management initiatives that you were told would be implemented. Is this correct?
Yes.
And why select 15%?
This was the risk manager's collective estimate of the impact of the initiatives.
So you relied on the views of these risk managers who were much more experienced than you in risk management initiatives and who were responsible for implementing these initiatives. Is that correct?
Yes.
Ms. Schroed, when an actuary forecasts future claim experience, isn't the actuary required to take into consideration changes that occur that impact claim costs?
Yes.
So would you not agree, Ms. Schroed, that had you not reflected this 15% cost savings that was anticipated by the risk managers, that you would not be following accepted actuarial practice?
Yes, I agree.
Ms. Schroed, you stated earlier that you did not disclose your reliance on this assumption in your actuarial report. Is this correct?
Well, I did disclose the assumption. I just failed to disclose that I had relied upon the judgment of the risk managers in making this assumption.
I see. And did you discuss this assumption in your presentation to the board in October 2015?
I most certainly did.
And when you did you explain the source of the assumption?
I most certainly did.
Marvelous. Thank you for clarifying that. Now, Ms. Schroed, you explained to Mr. Gambini that in adjusting your reserve estimate to reflect the time value of money, you used a 6% investment relative to return. Is that correct?
Yes.
And you used it because you were asked to do so by the ABC manager?
Yes.
Now, Mr. Gambini suggested that you should have questioned the reasonableness of a 6% investment rate. Do you agree?
No, I do not feel qualified to assess the reasonableness of a selected investment rate, nor was I asked to assess the reasonableness of the selected investment rate.
But did you disclose your reliance upon the ABC manager for this assumption in your report?
In my report, I clearly state the following. The interest rates used in this analysis have been provided by the client. An assessment of the reasonableness of the interest rate assumption is beyond the scope of our analysis. As a result, we express no opinion on the appropriateness of the interest rates used in the discounting calculation.
Mm-hmm. And didn't you discuss this with the board at that October 15 meeting?
I most certainly did.
And you advised the board as to the source of this assumption?
I most certainly did.
And tell me, aren't 2 of the board members CFOs for their respective hospitals?
That is my understanding.
So would you think that a CFO would be in a much better position than you to assess the reasonableness of a 6% investment rate?
I would think so.
Thank you, Ms. Schroed. Now, you stated that the estimates you provided to ABC were actuarial central estimates, roughly approximating 55% confidence level. Is that correct?
Yes.
Why did you do so, and why did you not provide estimates at higher confidence levels?
I discussed this with the manager of ABC, and he in turn discussed this with ABC's auditors. The auditors insisted that ABC carry reserves that are established at the actuarial central estimate level, as this is in line with accounting standards. And so this is what the ABC manager instructed me to provide.
Okay. Now, wasn't the ABC manager aware of the volatility of medical malpractice claims?
I'm sure he was, but he followed what the auditors desired.
You followed the auditors. Okay. So this means that there was a close to 50% chance that the reserves carried by ABC would prove to be too low, correct?
Yes, all else being equal.
So how is ABC to prepare for this?
By either charging the hospitals a premium that is set at a higher confidence level or carrying a higher level of capital.
Did you discuss these options with the ABC manager?
Yes.
And what were you told?
Two things. I was told that the member hospitals had no appetite for charging themselves a higher premium. He said that the reason for forming the reciprocal was to reduce costs. He also said that while he acknowledges that there was about a 50% chance the premium would be insufficient, there was also a 50% chance that the premium would prove to be excessive.
And what else were you told?
I was told that the new Troy regulator only requires newly formed reciprocals to initially carry $3 million of capital. And so this is what was decided ABC would carry.
Did you try to convince them to carry more?
I expressed my concerns to the ABC manager.
So, Ms. Schroed, to what do you attribute ABC's current financial position?
It's unfortunate that ABC's financial position is what it is, but it is due to ABC not fully understanding and recognizing the volatility of medical malpractice insurance. ABC should have charged itself a higher level of premium and/or carried more capital, should not have been so optimistic about the impact of the risk management changes it implemented, and should not have instructed me to apply an investment rate of 6%.
Okay, and what else could ABC have done?
I should have been asked to perform a mid-year study, at least in 2018, so that the deterioration in claims experience could have been identified sooner.
Did you suggest this?
Yes, but I was told that ABC did not have the budget for an interim actuarial study.
Okay, thank you.
Mr. Goodman, does this conclude the testimony of Ms. Schroed?
Yes, it does, Your Honor.
Thank you, Ms. Schroed. You're now excused. I will now give you, the jury, your instructions. Before you leave for the jury room, I have a few instructions for you. I've created a handout of applicable laws for this case. You are required to accept my instruction as the law. Any ideas you have of what the law is, what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. I've also prepared a jury verdict sheet, which I believe should make your task simpler. I will be sending that sheet with you to the jury room. The sheet has questions that you must consider and answer within the framework of the instructions that I have given you. Your first task will be to appoint a jury foreman who will be responsible for recording the answers to each item on the jury verdict sheet and submitting the results to me. Your answers to the questions on this sheet will serve as your verdict. Let me take this opportunity to thank you for your service on this jury. Ladies and gentlemen, you may now retire to the jury room for your deliberations. I thank you.